All right, it's 12 o'clock. We shall get started. My name is Vishal Sharma, and I'm your moderator for today's session. I'm joined by Prashanti Reddy today. A quick introduction about Prashanti. Prashanti is an alumni from the University of Pennsylvania Law School. And she has been in the immigration field since 1997. She's been admitted to the bar in New York. She's a member of the American Immigration Lawyer Association as well as the New York Bar Association. She wears the hat of Immigration Chair for the National South Asian Bar Association and Immigration Co-Chair for the Federation of Indian Associations. She's currently actively involved in pro bono legal work as well. And that on that note, I would like to welcome Prashanti, and then Prashanti, the floor is yours.
Today we're going to be talking about H-1B cap, H-1B registrations, mainly H-1B registrations. We have a lot of new information for you. The very latest information, something that was announced, in fact, yesterday by USCIS with reference to when the H-1B registration is going to start, what are the differences, what is new this year with the registrations, information about the fees, the increase of fees, and when that's going to happen, and what the fee increase is going to be, and a lot of other information with reference to how to file registrations, what to look at when you're filing a registration, and briefly some information about RFEs, H-1B RFEs, and what to expect. And of course, most importantly, we will be taking your questions. So that's very important to us to answer your questions. Also, we have some questions offline. So we will first take questions from people that are here live, and then next preference would be questions that have been posted previously offline. So Michelle, you can start with the first slide, the immigration updates for this year, for this cap season. So this is, as I said, there's a lot of important information, the latest information available on H-1B registrations. And so let's dive into that directly. The H-1B registrations final rule, there's been significant change in the way registrations are going to be done this year when compared to the previous years. As you know, or for those of you who don't know, last year was a mess because of multiple registrations. Beneficiaries filed duplicate registrations. Some beneficiaries filed 5 registrations and 10. I heard that one beneficiary filed 100 and more registrations. So what happened is because of that, USCIS has been looking at those multiple registrations, and they want to make sure that the beneficiary has a valid job offer for each registration. And so they sent out, once the registrations were done, they sent out an advisory that if there are multiple registrations, then they would be looking into it carefully to see if there's a valid job offer for each registration. So as a result of that, many beneficiaries got scared and did not proceed with their H-1 even though they were picked in the lottery. In addition to that, companies colluded and filed multiple registrations. When I say colluded, they got together with other companies and filed the same beneficiaries through both companies or through the 3 companies or 4 companies so that they could share resources once they're picked, so that they could increase the chances of the beneficiary getting picked. So that collusion is not allowed, and USCIS sent out again an advisory that If they found any collusion, they would take serious, action for fraud. And as a result of which also a lot of people who filed, who colluded, a lot of companies did got picked in the lottery but did not proceed with their H1 filing. So a lot of H1s, as a result of which a lot of registrations were wasted, and USCIS had to do another lottery pick where they picked about 75,000 cases there also in the second lottery. And it was basically a mess with not many employees as usual filing. So this year, thankfully, they came up with some additional rules that would kind of discourage beneficiaries from filing multiple registrations. So this final rule is expected to take effect on March 4th. That's 30 days after the official publication. So that means this rule would be in effect for this particular cap season. And basically the rule is that the registration, the lottery would this time be beneficiary centric, where USCIS will select the lottery by unique beneficiary rather than by registration. So this new process is designed to reduce the potential for gaming the system by filing multiple registrations without a valid job offer. So this way, when beneficiaries know that no matter how many registrations they file, they'll only be picked once based on their passport ID, passport number, they no longer will file multiple registrations. So this is something that everyone has been suggesting USCIS do, but they haven't done it earlier. But thankfully, they're doing it now for this cap season. Also, another update is that the start date flexibility. So they'll allow for a start date, any start date, as long as it's after October 1st. They're being a little flexible with the start dates. Anything after October 1st, as long as it's within the same fiscal year. So October to October is when the fiscal year is. As long as it's within the same fiscal year, they will accept that start date. So keep that in mind. So start date, the lottery pick being based on the beneficiary ID. And third is some measures have been taken to codify USCIS's ability to deny or revoke H-1B petition, where the registration contained a false attestation or was otherwise invalid for some other reason. And USCIS then has the power to deny or revoke even the H-1B petition after it's approved. Also, if the fee is declined, then and they're not able to reconcile that and they're not able to get the fee, then also they could invalidate a submission. So two things. One, they could deny a H1 or revoke a H1 after approval, or deny a H1 after it is filed if they find that the registration attestations were incorrect. For example, if they say, if there was no valid job offer, for example, and the registration was done, they can easily, on that basis itself, deny the H1. Also, if the fee doesn't go through at a later point of time, it first gets approved and doesn't go through for some reason, then as well they could, invalidate that H-1B submission. Next slide. Another announcement pertaining to the H-1B registration. They have announced the actual date of when H-1B registration will open up. It opens up at noon on March 6th, 2024, and the registrations can be submitted until March 22nd, 2024. So start date March 2nd and end date is March 22nd, 2024. And since this is going to be beneficiary centric, USCIS will require all registrations all beneficiaries to provide valid passport information because they're going to be doing it based on the passport. And if there's no passport, then valid travel document can also be used. The passport or the travel document used by the beneficiary, if they are abroad, it should be the same passport that they will use to enter into the US. And if if they're already in the US, then it should be the same passport that they will use to file the H-1B petition. So please make sure that all of you renew your passports before filing for registration. Also, they have, as of February 28th, that's another date to keep in mind, USCIS will allow you to open new accounts for registrations. They've made some changes with reference to how the accounts work. So that's been changed as well. That's another new update. They're now calling them organizational accounts, and now using one account, multiple people can log in at the same time. So multiple people will have access to the same account, and you can have more than one administrator and more than one user for the same account. Whether you're a legal representative or you're a company, that is possible, right? So important to keep that in mind. And on February 28th, if you don't have an account, then you can create an account. And if you already have an account, you can very easily change that to and upgrade it to an organizational account. You don't have to create a new account. You can use the same account from last year, but you'll be given the prompt to change the account into this new organizational account where more than one person can access it, and you have admin. For each user, you can decide whether you want to give them admin privileges or just user privileges. Next slide. So representatives may add clients to their accounts at any time, but both representatives and registrants must wait until March 6th to enter the beneficiary information. So while you can activate your account, you can open your account, you can't actually enter information into the account until the registration window opens up, which is, as I said previously, March 6th. And also on February 28th, same day, USCIS will also launch an online version of the I-129 petition for non-cap H-1B petitions. And as of April 1st, they launched the online version of I-129 petitions for all cap cases, for all the files associated to the H-1B. So what they want to do is that they're trying to encourage people to now file H-1B petitions online instead of sending H-1B petitions by mail. And they're encouraging people to do this. They're providing them with incentives. They're saying that there'll be a lower fee if you file online rather than filing by mail. And also the advantage that they're saying there is that the receipts, RFEs, everything will be available to you online if you file online. So that's a huge plus rather than waiting for the RFEs to come, waiting for receipts to come, and that mail gets sometimes gets lost by the post office, and then we have to ask for duplicates, which they don't send immediately. So that's a big issue right now, and that can be resolved if everything is available online. Also, the USCIS recently announced that there'll be an increase of the premium processing fee, and that fee will go into effect earlier than the other fee increases. So that will be in effect as of February 26, 2024. And talking about the fee increases, USCIS, this is another rule, another update. So there are a lot of updates, as I just mentioned. This is another update under the final USCIS fee rule. There'll be a dramatic increase in filing fees. So the fee for a H-1B petition, which the basic fee, there are many fees for the H-1B petition, but the basic fee of $460 will increase to $780, while the fees for an L1 petition will increase from $460 to $1,385. Registration fee will increase from $10 to $215, but please keep in mind, there will be no increase of registration fees for this year, as the fee increase is taking effect on April 1st, which is after the registration period. So we will not see any increase in fee for registrations, at least for this fiscal year. So also H-1B petitions, once cap filing begins on April 1st. Can you, next slide, please, Vishal? For those cases, the April 1st cases, cap cases, the filing fee for USCIS I-129 filing fee will increase. Also, in addition to the increase of the fee for the basic fee, there'll be something called an asylum surcharge that they're talking about. And we have to look into this further, but there's a $600 additional fee for all I-129 and I-140 petitions. The final rule reduces this to 300. Proposed rule said it would be 600, but they've reduced it to 300 for small employers. So employers who have 25 employees or less will have to pay $300 instead of $600 in addition to the increase in fee, the basic fee. And nonprofit organizations will not have to pay this asylum surcharge fee. So basically, they're charging for the asylum program, since they are saying the asylum program, to keep it open, is expensive. They're charging a surcharge for business cases. Also, nonprofit and small employers, that is, employers who are 25 or fewer, filing form I-129 will pay a 50% discounted fee. So, or the same fee if the discounted fee is less than the previous fee. So if it's the fee has increased from 460 to 780, and 780, if the discounted 50% off of 780 is less than 460. So for employees who have employers who have less than 25 employees, they will not be an increase in fee. So that's the caveat. So it will still be 460, but still there'll be a surcharge, which is the $600, which will be 300 for small employers. Bigger employers will still have to pay both the fees, the increase in fee as well as the surcharge of 600. But as you can see, there's a significant increase in the filing fee for I-129 this year, unless you are an employer who has less than 25 full-time employees. It could be full-time equivalent, meaning if you have 2 part-time employees, that would be considered to be 1 full-time employee. Next slide. Now let's talk a little bit about the registration process. I want to move this along so that we have time for questions. Almost halfway through the show. So what is needed for the H-1B registration process? It's the same information that was needed last year, except the passport ID is a must. Last time it was optional. So the legal name of the beneficiary, first, middle, family name, the gender of the applicant, the option, you have to select whether it's a master's cap, you're filing under the master's cap, that's a 20,000, or the general cap for a bachelor's. If it's a master's cap, it has to be from a public or a non-profit organization. Date of birth is needed, country of birth, country of citizenship, and as I said, passport number is now not optional. Next slide. That's the information needed from the employee or the beneficiary. From the company, you need the name of the company. If there's company is doing business as, you need that information, the company's employer identification number or the EIN number, and of course their US office number. So some do's and don'ts. If you already have an account, please check your account and update it to the organizational account, and also make sure that it's active before March 6th. And when you create an account, please make sure that you enter the proper information into the account. Also, if you enter the wrong information or you select the wrong category, then you will not, it won't work. So you might have to then delete that account and create a new account. So just make sure you're creating the correct account by following instructions. Next slide. User email. The email that you use should be the same email that you share with your legal representative, because that's how they match the petitions. Although I hear that this time they're doing things a little bit differently and the process is more seamless. Let's wait and see. But also the beneficiary's name, please don't use placeholders such as first name unknown, last name unknown, no name given. These are placeholders that are used in passports sometimes when they don't have the first name or the last name. So please make sure you don't use any of those placeholders. Keep in mind, LCA is not required at the time of filing registration. LCA is required only once your registration is selected in the lottery and you're ready to file the H1. There's no option to edit an already submitted registration. So please make sure that you look through all the information, review it, double check it, and then submit, because once you submit it, you cannot make any changes. Make sure you mention the name of the beneficiary as per their passport. If you mention a nickname or a name that is not in the passport or a middle name that doesn't appear in the passport, then they will question it when you file the I-129 petition as to whether it's the same person or not. Next slide. This is just a brief timeline with reference to how this year's H-1B process is going to look. So March 6th, actually February 28th is when you'll be allowed to create or update your registration accounts. So make sure you do that. March 6th is when the registration starts. March 22nd is when it ends. We will hear the lottery results. We will know the lottery results before April 1st. So sometime in between March 22nd and April 1st. And then we actually have to file the H-1B petition between April 1st and June 30th. So you have 90 days to file. Next slide. So this is just an overview of what the registrations look like over the past few years. This is a very interesting table to look at. As you see, the highest number of registrations were done last year, 2024, 758,000 registrations compared to 474 from 2023, so almost double. So if you look at if you see that there are all multiple registrations, you look at the number of multiple registrations, 400,000 multiple registrations last year, and the year before also 165,000. So you look at it, the multiple registrations keep increasing since 2021. But if you look at the number of actual registrations filed between 2023 and 2024, if you don't count the multiple registrations, they're pretty much, it's only about 40,000 more, which is still significant, but not as significant as being double. So 309 versus 350,000, which is still, a lot. If you look at the number of registrations selected, it was 188,000 selected in 2024. What does that tell you? It tells you that people file registrations, but not many people actually file H-1Bs. So they had to select more, have two lotteries and select more people, because people were not filing their H-1s after doing the registration. So 188,000 versus 127,000 selected last year, and the year before the selection was slightly more, 131,000, almost 132,000. So this gives you an idea of what to expect for this year. We should expect that the registrations will be around 350,000. Maybe since we expect that there will not be any duplicate registrations, as there's no longer any incentive for duplicate registrations, we can expect about 350,000 to 400 registrations this time. And the pick rate will be, if this is, the number of registrations, and the selection is about 130,000, pick rate will be about 30%, the same as previous years. It's getting less and less, but I'm hoping it'll be at least about 30% this year. So 1 out of 3 cases will be picked. Next slide. So when you file registrations, most people think that they don't need to look at anything. You just, get the name of the person and, basic information and file. But, you should review your all the information before you file a registration, because once you file the registration, if the person doesn't qualify for a H-1 due to various reasons, then you're just wasting your registration. And USCIS could also ask you as to why you did not file your H-1 once the registration was approved. So it's important to, avoid RFEs and therefore increase your chance of getting an approval. And all that can be done by reviewing all the documentation before you file the registration itself. So the most common type of RFE is the failure to establish that the position qualifies as a specialty occupation. And it doesn't help, especially since USCIS has narrowed its interpretation of what qualifies as a specialty occupation. And USCIS often challenges positions with duties that don't appear to be complex enough to require a bachelor's degree in a specific field. So it's important to, when you're filing the H-1B petition, to list the duties, roles and responsibilities in detail and show, the complexity of the role. And, there has to also be a link between the job description, the work to be performed. Suppose it's a software engineer and you put a job description which is completely different from a software engineer, then, that doesn't make any sense. They won't approve it. And you also have to show that there is a correlation between the education as well. So software engineers should require a bachelor's degree in computer science. If you're requiring a bachelor's degree in electronics or something completely unrelated, such as chemical engineering, then USCIS will again might raise an RFE asking why you require a degree that is completely unrelated. Next slide. So another reason why we get RFEs is when the employer fails to establish that they have specific non-speculative work in a specialty occupation for that particular person. So you have to show that you have work, and you have to show that it is H-1B caliber work, requiring a bachelor's degree in a specific field. The person could be working in your office for an internal project, or could be working, we're talking about the consulting, IT consulting scenario. They could be working for a client, or they could be working on an in-house project as well. If it is an IT consulting company, then it becomes sometimes more difficult to show availability of work, and because they are more stringent in asking that kind of information, as opposed to if you're working as an attorney, for example, they will not really ask you for to show that there is availability of work. They don't usually ask for that, but in the consulting scenario, they do. So if the work is at a client site, then you should provide some kind of letters and something, an end client letter or a PO or an MSA, whatever you have, a vendor letter, to show that you have some kind of work for them. Next slide. On the other hand, if the person is going to be working on an in-house project that has its own challenges, and as you can see, the list of documentation that they can ask. If you're saying that you have your own product and they're going to be working to develop that product, there's so much fraud in this space that they ask for a lot of information. And you can see the information here, what all they're asking. Keep in mind, I'm not going to read through everything, but they ask for all this information. So be prepared to be able to submit this, or submit it, I would say, while you're submitting the H-1B petition itself. Next slide. Yes, that's it. So we're ready for our question and answer session.
Yes. So we do have some questions offline as well, so we'll try to get through them as well. But in the meantime, I'll pick on some of the questions that we've received in this session. So if you have any questions, again, a reminder, feel free to add your question in the chat window, and we'll be picking them up one by one. Just going through the list here. I think one of the questions was already answered. So one of the first questions, I'm just going to look for the next one. In the future, if I wanted to establish my company, consulting company in the US, and hire at least 3 to 5 resources, FTE, what's the process involved? Time frame, approximate capital investment, including the visa, attorney, and other fees. Please help me know the process.
In the future, if I wanted to establish my company, a consulting, so someone wants to establish a consulting company in the US and hire a few resources, you could do that. What's the process involved? Depending on who the resources are, if they're US citizens or permanent residents or people who have EAD cards, you don't really have to file a H1. You can hire them as long as you're following all the other rules with reference to the Labor Department rules, by paying them a fair salary, file your taxes on time, etc., etc. There is no the investment that you make has nothing to do with immigration. That is the investment that you need for your business. USCIS doesn't care what your investment is as long as you're able to show that you have a job for the particular person that you're hiring. That's all that's required. There's no need to show that you have a particular number with reference to revenues, right? Or you don't have to show that you're making a certain amount of dollar amount in profits. So as long as you have a commercial office space, you have, of course, you've incorporated your company. That's good enough for USCIS. Also, capital investment, including the visa, attorney, and other fees. So the visa and attorney fee, the attorney fee really depends on the attorney. So that could vary. But depending on who you use, it could be 500 to 5,000 really. So the USCIS fee is of course fixed, and it's about 1,700 to 2,500 depending on the number of employees. And if you have premium processing, then it's another 2,500. And now with the increase in fee, the fee has become more as we discussed. So yeah, I think that kind sums up and answers that question.
Yes, certainly. And I do see some of you are using the raise a hand feature. So first of all, appreciate that. However, what we would suggest you to do instead is drop in your question in the chat window, and we'll be happy to help you there. Next question is, would you have links to share for creating the accounts? Is that some organization do, or would the law offices do if we were to engage you?
So the good thing is now we can open the account for you with this new setup. I think it doesn't matter who opens the account. We can certainly open an account for you as well. And we could also share how to open an account with you as well. So you could, just email me offline, and I can be happy to do that. Or if you need help opening an account, I'll be happy to do that as well.
Great. The next one is, does the beneficiary have the option to choose a filing company after registering through multiple companies? If so, how is this selection process facilitated?
So yeah, that's a good question, because if they file 5 H-1B registrations and they get picked only through one, of course, when they're filing 5, we're presuming that they have a valid job offer with each one of them. Then they get to choose, so then when they file the H1, they're only using one registration, only one number. So if they file the H1, they can choose which H1 to file it through, because unless they're working concurrent, in which case they would file a H1 first, get an approval, and then file another H1 as concurrent if they're working 2 jobs. Otherwise, yeah, they'll have to pick and choose. They'll have to choose which job offer to take. And that's up to the beneficiary.
Okay. Great. Moving on to the next one.
And we might not even have multiple registrations, because there's no purpose anymore to have multiple registrations, because there's only one pick. But I understand that sometimes as a backup, when they don't trust the company, or they just want to feel safe that, in case one job doesn't go through, the other one, they can file the H1 through another company. Some people will still do have, multiple registrations.
All right. So that's the answer. Moving to the next one. What about if someone transfers his H-1B to other employer? Is there any impact in shed of the new policy?
Transferring, when we're talking about the new policy, we are talking about, right now, we're only talking about the H-1B registration policy, how they're not allowing, how they're going to be doing the lottery based on passport number. So that doesn't have any implication for a transfer. It's only for cap cases, right? The rest of the regulation has not yet been finalized with reference to specialty, occupation, etc. And this is just part of that big regulation. So they have fast-tracked this particular portion, and it only applies to cap petitions, not to transfers.
Okay. Next one is, my name is picked well, rather, my name was picked in last year lottery, but employer was not able to file the I-129. Is there any other impact to get registered this year?
No, is there any impact to get registered this year? There's no impact. You can file for a registration this year.
There you go. That's pretty straightforward. Next one is to validate, you can use multiple registrations, but a single H-1B filing. So the same passport number is used for multiple registrations.
Yes, you'll only have one passport number. So you might file multiple registrations, or different employers will file a registration for you, but they will pick up your case based on your passport ID. And since you only have one passport number, they will only do, there's only one pick in the lottery for you, for those people, for anyone. So there's, as I said, there's no advantage in doing multiple other than the fact that, you're not sure whether the, given company A will file your H1 or not. If you're not sure of that, then you would do, more than one. But otherwise, from the lottery point of view, there is no advantage in filing multiple registrations anymore, because no matter how many registrations you do, you will get only one pick in the lottery based on your passport number.
Okay. Next
And
one.
also, just to reiterate, you can decide to file more than one H1B as well. But finally, if you file multiple H1Bs, there is something called the last action rule. Whichever H1B you file last, that H1B will be valid, and the other one will not be. So, if you're filing multiple for some reason because you still haven't made up your mind, you'll have to withdraw one of the H1s, or your employer has to withdraw it before it gets approved. So my suggestion is, since you don't have the authority or the power to withdraw H1, only your employer does, if you're a beneficiary, it makes sense to file only one H1, because otherwise, it might be a mess, especially if you want to go with the first H1 that you file instead of the second H1 that you file. You may not be able to do that.
Interesting. Moving on to the next one. New beneficiary rule is a bit confusing and hard to understand. Can you help with an example if you can?
I think it's pretty straightforward. So basically, if a person files a registration through company A, company B, company C, company D, so the person filed 4 registrations, or rather the company filed registrations for them, A, B, and C, and D company filed a registration for Thomas. Now Thomas has 4 registrations, and in last year, he would get 4 chances in the lottery because he had 4 registrations. But this time, Thomas, no matter how many registrations he files, will get only one pick in the lottery, because they're going to pick out Thomas's number through their passport ID, and he has only one passport ID, right? So they'll see that they're duplicates. They'll identify duplicates based on the passport ID, and then they will put him in the lottery only one time. So hopefully that's clear now.
Yeah, that's a good one. I'll go through the next one. As the H-1B petitions are very close to be filed, how can one acquire a job offer from a US employer in such a short slice of time? How can your firm help in acquiring a job role, acquiring a role?
We can't, and as you rightly pointed out, it is not our domain. We do not do recruiting. We are immigration attorneys, and our expertise is in advising you on immigration law. So once you have a job offer, then we can advise you on how you should, then file for your visa.
Hope that answers that. Do your firm process Pakistani passport bearers?
Immigration is the same for any country. The process is the same, so we, absolutely, yes.
Great. Moving on to the next one. I've been on H1 for almost 5 years, 10 months now, moving to H4 starting from March 30th. By that time, I would be left 2.5 months on my current petition. One, am I eligible for fresh H1 this year since I haven't used complete 6 years on current petition, or 365 days cooling period staying out of US is required?
So basically he's asking, this person is asking if, if you leave the country for a year and come back, then you get a fresh 6 years on their H1. And this is important for people whose 6-year term has expired and they have not yet filed an I-140 or a labor, which allows them to extend their H1 beyond the 6-year limit. So then they have to leave the country, come back, and when they come back, they're actually cap subject, which means that they have to file under the cap, and file for a registration and go through the lottery, etc. So this person is asking, instead of leaving the country, if they file for a change of status to a H4 and stay on a H4 for a year, then does that suffice to get an additional 6-year term? And the answer is no, it doesn't. You have to actually leave the country to get that additional 6-year term.
Okay, great. Next one is, we filed amendment for beneficiary and he finished that project. And now we want to file amendment plus extension at a time with new project with still 1 year of H-1B validity left. Can we do 1 year before H1 extension plus amendment?
Yes, you can do a H-1B extension plus amendment. You don't have to wait for the H-1 to expire, or you don't have to wait for it to expire, and apply 6 months before. You can do it now. When you're filing the amendment, you can ask for an extension as well. And it makes sense to do that. Because the less number of times you file a H1, the better. You're decreasing your liability. Every time you file, there's a chance of denial. So, it's best to keep it to the least number of times as possible. Less number of times you file with USCIS, the better.
Okay. Moving on to the next one. Who will get notified when beneficiary is selected in case of multiple registrations?
The employer gets notified. I'm thinking because it's an employer-centric system. So all the employers, I'm presuming, who will get notified, and then the beneficiary has to decide who to go with. And I don't know exactly how they will notify them. I'm just presuming that if company A, B, and C and D filed for Thomas, then A, B, C, and D will be notified that Thomas was selected. And then Thomas decides, who he wants to file the H1 with.
Okay. Next one is, if person had previously filed H-1B and want to file again fresh this year, will it be possible?
Yes, I don't see why not. You can file any number of times as long as you are in status at the time of filing.
Okay. The message goes along. Do you also entertain transfers if previously approved H-1B petition never used, but visa never pasted?
I think they're saying that if we can file a H-1B, if previously a H-1 was filed under cap, but they never used the H-1 and they never used the visa, or they never got a visa, then yes, I think they're still H-1B cap exempt, and we could file a H-1B at any time for them.
Great, hope that answers. Next is if a person has approved H-1B petition from 2016 lottery but didn't attend visa interview, can he use that petition to change of employer under cap exempt?
Yes, I think we just answered that question. It's the same
Right.
answer, yes.
Okay. I was recently involved in a minor accident. My car was fine, no repairs claimed, but the other car had damage. Insurance determined it was my fault, an honest mistake. I was not issued a ticket or anything. I have a clean driving record. Apart from this, I will be filing for H-1B in March. Can this accident affect my H-1B chances? I have a pretty clean record apart from this. Looking for advice.
I don't see an issue with getting a H1 if you have a traffic violation, which is what you have. As long as it's not a criminal offense, you were not involved in, you didn't hurt someone due to your negligence. There is no issue with a traffic violation. So yes, you can apply for your H-1B.
Okay, great. I think that is all the time that we have for today's session. We would be scheduling the next session pretty soon. So please do check your inboxes and or your LinkedIn for an invite for the next webinar. On that note, Prashanti, thank you so very much for all your time and a wonderful session here today.
Thank you everyone for attending and look forward to seeing you next time.
So on that note, we would be wrapping up the session.